Ladies and gentlemen, good morning, and thank you for having me. It's a real pleasure for me to be here, and I was trying to calculate this morning how many times I've had the opportunity to speak at CROBECO conferences, and it's difficult for me at the moment to say that I really still feel like an independent academic advisor. I mean, we've worked together for so long. I feel much more part of the CROBECO project than I realized in preparing. So I thought I should say that before that. So when I say we, I actually mean you, formally, but of course it feels very much that like us. I will come back to that in a second. Now, I have been asked to speak to you about the issue of reliability or the issue of certainty, and I've made an advice together with Professor Van Erck, also from the University of Maastricht, and our aim is really to, let's say, to re-envisage the CROBECO process, to really see, okay, so what have we done until now, where are we heading, and in terms of, because that's really what we're doing, of course, we are really building a chain of trust, we are really building connections between, let's say, from a Spanish perspective, a foreign buyer, all the way towards the registration of the title at the end of the process. And we are really building, and that's really, at least when I look back on what we've been doing in the last couple of years, we've really been building this chain of trust with each other. And that road, I think that's important also to stress, that road has not always been linear. The road has not always been easy, and sometimes we've stumbled upon controversies that we perhaps didn't know existed before. But I think the important bit is, and that's really important to emphasize, is that after, let's say, 4 or 5 years of actually thinking about this, working on this, we are still going on, and we are still the process of this chain building, or the process of the trust building is still ongoing. Now, in respect to this CROBECO process, we've really, until now, envisaged, or we've worked from the perspective, I think now, of 4 different parties. And we've always talked about, and that's how we started, from the client perspective, so from a citizen in a member state of the EU. And we started out with Dutch citizens wishing to buy and acquire property in Spain. We talked about notaries. We talked about, and I'm for the purpose of today, I'll call them information services, but of course by that I very much mean the gestores that we heard this morning. And of course, and I think this is where we started out from the perspective, we have really talked a lot about land registration and the way in which land registries function. Now, in terms of those registries, the starting point of how we developed CROBECO and how we started building this chain of trust has really always been the registrar. That's where we started. So we sat around the table with registrars and we tried to see, okay, so how can we, from the point of view of registration, ensure legal certainty, protection of the parties, proper transactions, choice of law, choice of jurisdiction. And that really gave shape to the CROBECO project as we started it. But now, I think that CROBECO is maturing a little bit, and we are really starting things are starting to get really, really serious now. I think it's time, at least that will be my submission to you, it's time to change perspective a little bit. And I think instead of approaching this from the registrar side, we should approach this now, at least take a look at it from the client side, so from the citizens side. Because when we are talking about creating certainty, and that's really what we are, at least that's what I will be speaking about for the moment, it is the certainty, of course, for the legal system, of course for the registration system, but it's the certainty for the client that we are now focusing on, and for, of course, the notary that is representing that client. And that creates a new level of complications that previously we had not really discussed, or previously we hadn't really delved into the specifics of that. So my task today, which is very uncharacteristic of me, if you heard me speak before, because I like big topics and a lot of EU, but today I will try to be very, very specific and go into that relationship client-notary, and then in particular, notary to the investor. Yeah? Of course, there's more to CROBECO, and there are other speakers who will address this, but this will be my topic. So how can we create certainty, not absolute certainty? I mean, I don't think that exists in general, but certainly not in international transactions. But how can we achieve, I think that's the aim, a level of certainty that makes it possible for all parties involved to work. And that question, as I will show, is heavily determined not so much by the parties themselves, but by the statutory framework within which these parties must act. In particular, the statutory, so the legal liability of the parties involved, as well as the insurance that they have. And this, so I apologize beforehand if this is going to be a bit boring, but I think we have to go through this, and particularly to the questions of liability and insurance, to get back to where we need to be in this chain of trust. And we really have to zoom in for a second. Okay, so how can we persuade a client, that's one, but in particular also a notary, to participate in this in such a way that the notary can fulfill all of his or her obligations. But also if that notary asks information from the castle, then can the castle also do his or her work and resolve or avoid being liable where he or she should not be liable. And we'll see a presentation later of how notaries get into contact with castles and how they can perhaps conclude a contract with them, and how the NetPro system, because that is really what we're talking about, how that will work. So I will leave that aside also for the moment. So when we're talking about creating certainty in this notary, so client, notary, castle chain, or part of the chain, I think it's important just to take into account, or to keep taking into account, the EU framework. So the EU framework of applicable legislation here, there's loads of legislation of course, but I mean in terms of framing the contractual relationship, we have the Rome 1 and Rome 2 regulations that deal with, and Rome 1 deals with the law applicable to contractual obligations, and it determines, in the absence of choice by the parties, what law applies to the contract. That's Article 4. But it also allows the parties to choose the applicable law to their contract if they so desire, but of course within the limits of the contractual relationship between the parties, not necessarily in relation to the proprietary aspects of the relation. Because in terms of property law, and that has always been the starting point at the outset of the CROBECO project, the CROBECO project is aimed at respecting the lex recite principle, the law of the place where the land is situated, to eventually deal with the in rem, so with the proprietary effects of the transfer. The Rome 2 regulation deals with non-contractual liability, and that really becomes relevant, of course, in terms of a relationship between a notary and a castor, where the contract does not deal with the liability, and perhaps there are other issues of liability to consider. And also there we can take that a little bit into account. The Brussels 1 regulation, I'm just repeating this for the sake that everybody knows what we're talking about. The Brussels 1 regulation, of course, deals with jurisdictions and enforcement. And again, in the absence of any agreement between the parties, it determines to which court a certain person may go in order to obtain a judgment, or how judgments made by courts in other countries should be dealt with in foreign legal systems. And also there, again, you have the possibility to choose and basically to appoint jurisdiction to a court, exclusive jurisdiction actually to a court, that will then be authorized alone to rule on this matter. And then I think, and this is really new in terms of what we've always discussed for CROBECO, that in terms of inheritance and in terms of succession, we now have this unique framework provided for by the EU succession regulation. That again, I emphasize, is not without controversy, of course. And we don't really know yet And I'm doing a lot of work with the Dutch notariate on this. And I know that the European notaries are also dealing with this. We don't really know yet how this European certificate of succession is going to work, etc. Who's going to give it, who's going to recognize it, how it's going to be registered, etc. I don't think that's part of our discussion for today, but it is something to take into account because CROBECO and the CROBECO technique, and to that I wholeheartedly agree, can of course also be used in terms of succession, so the passing of property rights on death rather than inter vivos, as we call it in succession law, so among the living. So that's the EU framework that we're dealing with. But of course, at the same time, we also have to deal with national frameworks in the plural. And when we're talking about CROBECO, and that really creates a level of complication that we, of course, don't necessarily see at a national level. We are dealing, in this case, with Spanish law, with Portuguese law, with Dutch law, with English and Welsh law. And I just mentioned the four most obvious ones. But of course, as CROBECO looks across the borders for other countries, for example, to Greece, also Greek law, of course, will become of relevance. Now, I'm not saying that in every CROBECO transaction these four legal systems will apply. That's not what I'm trying to say, but I'm just trying to show that when you're talking about a CROBECO transaction, we are talking about a more complex situation with infinitely more possibilities for problems than when we're talking about a national, purely, let's say, internal or domestic transaction. And that really matters. So I'm spending a bit of time on this to talk to you about this, just to explain why this matters. So it means that the techniques and the tools that we have at the national level to ensure what we call certainty or legal certainty, they work, of course they work, in a national setting. But it is not automatically that they work in a national setting, that they will also work in a cross-border setting. And I think that's very important to realize. And there is therefore an inherent degree or a higher risk of problems just from the fact that you are not dealing with your purely domestic legal system, but you have several legal systems coming into contact with each other. And that we can resolve, of course, by making use of the rules of private international law, by making use of choice of law in contractual agreements, and we should. I'll come back to this. But it's important to realize, and I think for notaries also to inform their clients about this, there will always be a higher degree of risk in such an international transaction. And really, it doesn't matter in that respect whether you go to your own notary or to a foreign notary. I mean, the risk just exists on the basis of the fact that we are dealing with different countries, different legal systems. And sometimes, just by way of a quick example, sometimes persons, citizens, bring in their own legal system without explicitly doing so. I mean, we've had in the past few years a lot of cases in front of the European Court of Justice that deal with European citizenship and the effects of European citizenship, where really sometimes unexpectedly, for example, the civil status or the personal status of a person all of a sudden becomes of relevance without us, or without the parties at least, having realized that properly before. And it is also in that respect, and I didn't put that on my slides on the EU framework because it's law in preparation, that the European Commission is of course working on the so-called Rome 3 and 4 and 5 regulations. In particular, Rome 4 will deal with the marital property relationships between the persons that are married, and Rome 5 will deal with the property relationships between what we call registered partners. I mean, behind that is the issue of same-sex marriage and the recognition of same-sex marriage by, well, non-recognition in particular by some member states. So we have two regulations that will basically deal with the same topic. So, instead of the client, the notary, and the information service and the registrar, if we now focus on the notary and the information service, and I mean this really in a wide sense of the term, then there's a different type of situation that arises for a foreign notary than for a domestic notary. Because a Spanish notary is, of course, an expert in his or her field when it comes to the conveyancing of land in Spain. But a Dutch notary is not necessarily an expert in Spanish conveyancing. Of course, a Dutch notary can become an expert in Spanish conveyancing over time. But the situation that we are currently dealing with is a situation where for such a foreign notary, it will be more difficult to estimate what's going to happen than for a national notary. So I think therefore it's extremely important, and we should be extremely happy that the gestores can provide this necessary information to foreign notaries, so that foreign notary, and I think that's a crucial point, so that foreign notary can take his or her own responsibility and assess whether or not this is something to proceed with or not. And I agree with what you said this morning, that of course the notaries themselves have the obligation to decide whether or not they should continue with the transaction or not, whether or not enough legal certainty has been ascertained, or any other, of course, legal considerations that national notaries might need to make. So, I've taken 3 issues. I mean, there are 100,000 issues to talk about. I've taken 3 issues just to highlight a bit more. I mean, what we have to consider and what will differ from country to country, this is the phase of dealing with CROBECO, is of course the liability of the notary under national law. And that I don't mean tort liability, so if the notary necessarily commits an unlawful act, but really statutory liability for notaries. This is a regulated profession, regardless of what the European Court of Justice says about notaries being service providers or not. It's a regulated profession. And therefore, there's statutory liability under the home system of the notary that we have to take into account. And here, I think it's important that we realize and that we have to accept that national notary can only do his or her work within the framework of that national statutory liability. And so, the aim of making notaries join in CROBECO should really be, I feel, to respect and to take into account that national liability, and to respect the fact that notary has to make a decision whether or not this is a good transaction, this is a good conveyance, and then decides to pursue. But there will be notaries speaking about this later today, so let me, on the choice of the notary, let me leave that aside. But I think it's important for us to realize that notary must therefore act under his or her national legal system. Similarly, on the other side, also the gestores have statutory regulations and statutory liability, and we also have to respect that also the gestor has to act under his or her own system of liability. And that creates a situation that's not necessarily easily, of course, to resolve. So this is where I think NEPRO then should come in. So NEPRO then allows the notary, under his own applicable legal system, and the administrative agent, the gestor, to, under his or her other applicable legal system, to come into contact with each other, and then to create an agreement, basically a workflow, on the basis of which they can then cooperate. And that is essentially, again, I mean, it sounds almost ridiculous how many times we say this, but that is essentially, again, a relationship of trust. It's a relationship of trust on the side of the gestor, that the notary is indeed representing the client, and that this is a sincere transaction, and that all payments are going to be made, etc. And on the side of the notary, this is a situation where the notary must rely and trust that the gestor is going to provide accurate information, correct information, and in particular, all the information. I think this is a real issue, particularly that last bit. So how can we ensure that the national notary has received all the necessary information in order to make that decision under the national statutory liability regime to proceed with the transaction, and also to tell his clients, okay, now it's okay to put your signature down. And those questions, I mean, there are loads of questions, but all those questions we found out when talking to notaries are essentially a question of insurance. In speaking to notaries and speaking to gestores, it comes down to matters of insurance. So, I am not an expert in risks and in risk regulation, but of course this is a matter of risk regulation in its essence. So, at some stage, we and the parties involved have to assess the risk that they are taking and whether that risk is worth taking. And then I don't mean in the sense of cost and benefit analysis, but really in the sense of, okay, can I take this risk because it will eventually be covered by my liability insurance or not? That's a real, and in speaking to notaries, and I've spoken to a lot of them in the past weeks, that's a real concern. And the notaries really say, okay, and that applies for notaries both in the Netherlands and in England and Wales. They say, okay, I can only proceed if I know I'm covered. I can't risk going bankrupt or losing a lot of money over this, then I'd rather not do it. And that, of course, would be the opposite effect of what we want to achieve. So, in terms of advice, and now I'm rolling to the conclusion. In terms of advice, I would propose a roadmap. That's all I can do for the moment. And I would love to work, and the same goes for Stefan F. We would love to work further with you on this, but on the basis of where the project stands now, our advice is a roadmap, so to say, in terms of service contract, because that's what we're talking about, a service contract between a gestor and a foreign notary. I mean, from the perspective of the gestor of foreign notary. Essential ingredients there, I would say. But I mean, this is up for debate. But essential ingredients, therefore, I would say that this should be a contract that is a contract under the law of the notary, because it's the client that starts the proceedings, and the client comes to a national notary. That's the whole CROBECO idea, on the basis of dealing with that national notary as much as possible under the national applicable law. And I don't think, therefore, it would be a very good idea to then take the lecture secret rule already in this stage, and that we should really try to maintain the notary's applicable law. And this will greatly help and convince the notaries from participating. But I realize this might be a controversial point, but just from the perspective of the client, I would advise to do it like that. Similarly, I would then also take a choice of jurisdiction and declare and give the court of in the country of the notary exclusive jurisdiction over problems that might arise over this, just simply for the fact that if you choose the applicable law, you also want to have the national court that is in the best position to decide on that with there. And these two issues, I strongly believe, and therefore submit, will be crucial for the national liability insurance of notaries to go ahead with this. Then, I would propose as a roadmap that we make a standardized contract, and that this contract is as standardized as possible, so as to enable us to, because of course legal liability remains. And we can't, by contract, say, okay, all of a sudden the statutory liability doesn't exist anymore. But by a standardized contract, say if you follow these terms of the contract, then basically the insurance companies will be okay with it. And in order to do that, and that's why I won't propose any concrete text for the moment, to do that, we will have to sit down with Dutch notaries, with English notaries, with the gestores, with the Portuguese equivalents and any other countries, come up with a proposal for standard terms, and then go to the insurance companies. And I don't think there's another way to do that. And then we would really like those insurance companies to say, if you follow these standard terms and agreements, then the liability that arises on the basis of that contract is covered by the insurance policy that you have. And there, again, I would say, this is again a quick question of, okay, so the statutory liability exists, but of course by contract you can shift the obligation of payment between the parties. You can't resolve a Dutch notary, for example, of liability, but of course if the liability of the Dutch notary arises let's say, an unfortunate situation that existed on the side of the castle, then the Dutch notary will be liable for sure under applicable Dutch law. But of course, in the contract, the parties can agree that then the payment of the damages that arise from that will then be covered by the insurance company of the castle. Similarly, if the castor is liable because of the behavior of a foreign notary, then again you can agree, okay, but then the liability should be covered by the insurance company of the notary. And I think it's important on both sides that you make this agreement. That's again, it's an agreement of trust. But it's important that you make this agreement in order to persuade notaries and to persuade castors to participate in this. So, and then, as a final point, in this contract, I am wondering, I don't know if this is possible, but I am wondering if it's possible for the castor to add a declaration to the information that he or she provides, that this is all the information that was available, and that under Spanish law this would also have been the information that he or she would have delivered to a Spanish notary. I'm just wondering whether that's a possibility or not. I think this is something we can talk about. Because again, that clause, particularly the declaration that this is all the information that the castor could find, that would greatly help the notary in resolving and basically also excluding himself from that statutory, exempting himself from that national statutory liability, because then the notary can say, yes, I've done everything I could to find out information about this parcel. And in part of that, the notary then takes over responsibility from the castor, of course, for the purposes of his own liability. But then contractually we know that inside we can, if a situation would arise, we can resolve that. So, proposal would be to do this in a standardized contract. Of course, you conclude this online, you deal with e-signatures, that we ask for approval between quotation marks, because they're not going to give us approval. Like approval, you know what I mean by having a discussion with them and basically a basic understanding of, okay, if you follow the standardized terms of this contract, the insurance policy is going to cover you. And of course, but I don't know if that's obvious, but payments then would be electronic. I think that's the easiest way to do it. And then I would propose, but I don't know if that's important, but I guess it can be important, a retention of official documents, for example, until payment has been received, so that again, for the castor, you have a little bit of additional security before you hand over all situations. And so that brings me then back to NetPro. Because that NetPro is really the spill here in the information services. NetPro will only work if it then ensures a safe working environment for both the notary and the castor. If it provides a safe environment for the data that is on there, we really have to examine that and be very clear about the data protection issues, of course. And then if it does so, I think this could be an excellent platform, a really innovative platform for cross-border business. And that would really be something. I don't think sometimes we are so in the details, in the nitty-gritty details of this all, that we are forgetting how special this project actually is. And that, 50 years ago, or even 10 years ago, it would have been unthinkable, really, to speak about this. And that's how far we've actually come. This is really, I just want to emphasize that. This is really, really special. And I'm a young academic, but I've also been around for 15 years now as an academic, and it's amazing to see. So if we manage to go for the standardized contract, I really think we have a chance to resolve these liability issues, that we have a well-functioning NetPro environment, and there'll be other speakers about that later. And then again, we have a situation of trust between, in this case, the chain, the client and the notary and the castor, and of course also the notary and the foreign land registry. But that's obvious, because I think it's obvious for me, because that's what we started with the whole project. I think that's what I have to say. But I'm hoping there's perhaps time for discussion, even debate. And if necessary, I always put my contact details at the end. Of course, you can always spam me with your email later. And I will certainly be around for the next couple of days to talk about this further. Thank you very much.